A very good evening, Ms. Esmeralda. My name is Daniel Tan, and I'm from Bodge, Stodge and Hessel Solicitors. Today I would like to explain to you the general advantages of mediation and how mediation will be beneficial in your scenario. Let me start by explaining to you the general advantages of mediation. Why mediation and not the courts? Issue number 1, evidential problems. If this case gets brought forward to the courts, we will require a certain standard of evidence that will please the court. In your case, this includes deeds. Issue number 2, property devaluation. If this case gets brought forward to the court, and if a judgment has been established, the seller of your property will have to disclose neighborhood disputes to the future buyer of your property. Issue number 3, court orders might not please both parties, and this might further damage your relationship with Mr. Anakim. And finally, costs. It is very costly to hire a solicitor and to pay court fees. This will take up a lot of time and a lot of money. So now let's move on. I will now talk to you about why mediation is very important in your boundary dispute with Mr. Anakim. First, agreements are reached by both parties, and all proceedings of the mediation process are private and confidential. This simply means that both parties do not have to be afraid of leaked information. Also, this creates a very suitable environment for both parties to voice out their opinions without feeling afraid. Also, the mediator is impartial, and the mediator will look for the best way to solve the dispute. But this is a key ingredient in the mediation process, and all mediators are highly trained and highly skilled to be impartial. And this is one of the most vital aspects of mediation, and why mediation is suitable for your boundary dispute. The mediator also creates a chance for both parties to voice out their concerns in a more suitable environment. By saying that, I mean that there is no pressure, because both parties will not be present in a courtroom filled with judges and audience. Also, the mediation process is speedy and cost-effective. All mediators are trained to handle scenarios in a very short time frame and in a manner which saves more money. Finally, parties may agree on rights in which the court cannot. This includes easements and other rights beyond the scope in which a judge can impose. This is very important, because this is not just correcting a problem, but this is also looking for the best way to solve a dispute. I am now going to talk to you about this settlement agreement I have just drafted for you in the matter against Mr. Anakim. A settlement agreement is an agreement in writing of all the things that has been agreed by you and Mr. Anakim during mediation process. As you can see in this piece of document, all the agreed terms between you and Mr. Anakim has been written clear and precise. It is also binding. Therefore, all the do's and don'ts that has been established has to be followed and obeyed. As you can see, this document requires your signature. And to sign this piece of document means that you have agreed to all the terms and agreements that has been established during mediation process. Therefore, it is very important that you sign this piece of agreement. It is also beneficial that you do so, because all the things that have been laid out during the mediation process will then be effective from then on after the signature. Mediation process is a very useful process indeed. This is because mediation ensures that both parties come to agreement in a very suitable environment. It is also cost effective, and it also saves a lot of time. Therefore, I would like to conclude by urging you to sign the document, because this will be the best way to solve your boundary dispute with Mr. Anakin. Thank you.